Could Prince William become regent for his father, King Charles III, in light of the King's current health issues? This is a question I've seen popping up online since the King's cancer diagnosis was made public, and so today on History Calling we're going to take a brief look at regencies and protectorates of the past and at the current UK regency laws as enshrined in the 1937 Regency Act and amended by later legislation in the 40s and 50s. By the end of the video, you'll understand when and why regencies occur, who would become regent, and how likely it is that that scenario will arise during the current reign. I'll also explain to you what Counsellors of State are and how their powers differ from a potential Prince Regent's. Just to be clear before we begin, this video will focus on post-1066 English/Welsh history with the odd mention of Scotland too. Then, for anything from 1603 onwards, it will treat the crowns as one. It will not look at the history of regencies in other countries. Let's start with definitions. A regency occurs if the monarch is unable to fulfil the duties associated with that position, either by reason of their youth, because they are mentally and/or physically incapacitated, or in the very unlikely scenario that they are alive but unavailable. For example, they're being held for ransom in the way that Richard the Lionheart once was back in the Middle Ages. In that case, a regent is named who takes over the functions of the monarch without actually being the monarch themselves. In the past, a regent could also be appointed by the monarch if they knew they were going to be out of the country. Henry VIII appointed his first and last wives, Catherine of Aragon and Catherine Parr, to be his regents, for instance, when he went off campaigning in France, and George II appointed his queen, Caroline of Ansbach, to the same position when he visited Hanover. P.S. The queens could have councils to help them. Nowadays, however, with much faster modes of transport and communication, counsellors of state, who you'll be hearing a lot more about in a few minutes, can be appointed to fulfil this role, without the need for a regent, as the monarch is unlikely to ever be more than a day away at most. Even excluding the appointment of Queen's Regent by their husbands to cover for his absence, I'm still not going to go through every regency since 1066 here, as that's not the purpose of the video and it would take too long. But the most recent minority regency in England, which was actually termed a protectorate, though it amounted to the same thing, occurred in the 1540s and early 1550s for King Edward VI, who ascended to the throne at the age of 9. In Scotland, it was for King James VI, who ascended at the age of 1 after his mother, Mary Queen of Scots, was forced to abdicate. In both cases, the situation led to serious infighting amongst those who wanted to control the king and, by extension, the country. Edward VI's father, Henry VIII, had actually not wanted a regency at all. He had intended for there to be a council to rule the kingdom for Edward, but Edward's maternal uncle, Edward Seymour, quickly put paid to that idea and made himself Lord Protector. That didn't end well for him, as he was executed with John Dudley, Duke of Northumberland, installed as the new Protector, because, like I said, regencies/protectorates for minors were a messy business. James VI went through 4 regents of his own, for instance, 3 of whom died violently, and there were rumours that the 4th was poisoned. In the medieval era, a minor monarch such as Richard II could be allowed to rule even if they were less than 18 years old, but 18 has been the standard age for the king or queen to take on full royal duties for many centuries now. Regencies or protectorates for an incapacitated monarch are much more rare, with the 2 most notable instances in English history being those for Henry VI in the 1450s and George III between 1811 and his death in 1820. Both were because the king had had a complete mental collapse. In the case of Henry VI, his only child was born during his illness and so was too young to act as regent or protector. This led to a lot of bad blood between the Queen, Margaret of Anjou, and the King's cousin, the Duke of York, who ultimately took control repeatedly, and not always because the King was incapacitated, by the way, but that's another story. See my playlist on the Women of the Wars of the Roses to better understand what was happening there. In the case of George III, his oldest son was of age and available to be regent, but was hated by both his parents. Nevertheless, he was created the Prince Regent by Parliament when George III suffered what turned out to be a permanent breakdown, for lack of a better term. To learn more about that period of time, see my video on George III's wife, Charlotte of Mecklenburg-Strelitz. As late as the 1930s, though, there was no standard Regency law on the UK law books. Instead, Regency Acts were passed as and when needed, either because the monarch was incapacitated, absent, or expected to be absent, or there was a concern that he or she might die while the heir was a minor. Again, I'm not going to go through all these different arrangements here as I want to get to the current provisions, but just to give you one example, there was a Regency Act in 1830 in case the then Princess Victoria became Queen as a minor, which very nearly happened, by the way, as she was only a matter of weeks past her 18th birthday when her uncle William IV died in 1837. This was all very civilised, of course. Like I said, in earlier times there was just a mad power grab and whoever came out on top got to rule. As the 20th century got underway, the use of Counsellors of State became increasingly common. Unlike a regent, of which there is only one at any given time, there are several counsellors, and initially the way in which they were appointed and who they could be was not standardised, and was basically left up to the king. George V appointed 4 of them in 1911 by letters patent before travelling to India, and he nominated Prince Arthur, the Archbishop of Canterbury, the Lord Chancellor, and the Lord President of the Council. In 1928, though, there was a problem. The king fell seriously ill with a chest infection, and the Prince of Wales was out of the country. George was only just able to sign a document to approve the appointment of the councillors. The weaknesses in the system were beginning to show, and there were additional problems too. The recently independent Republic of Ireland disliked having UK ministers acting as go-betweens for the Crown and the Commonwealth of Nations, and so in 1930 it was agreed that future Counsellors of State would be exclusively drawn from the royal family. In January 1936, as the old king lay dying, he couldn't sign the document appointing councillors without his doctor's assistance, and it was clear that considerable reform was needed so that this ad hoc system of only appointing regents or councillors when it was already clear that they were or might be needed would be brought to an end in favour of a standardised system that could be implemented more easily. That brings us to the 1937 Regency Act, which, barring a few amendments over the ensuing years, is the act which dictates what would happen if a regency or councillors of state were needed today. Before we dig into it, let's just remind ourselves of what the royal family looked like at that point. George V had died in January 1936, leaving the throne to his eldest son, who became Edward VIII. He quickly abdicated, though, so that he could marry Wallis Simpson, and the throne passed to his younger brother, the new George VI. George and his wife, the former Elizabeth Bowes-Lyon, who you probably know better as the Queen Mother, had 2 children, Princesses Elizabeth and Margaret, who were aged almost 11 and 6 respectively. It also wasn't beyond the realms of possibility that he would have another child, maybe even a boy who would displace his older sisters in the line of succession. If George VI died before his heir or heiress came of age, there would therefore be the need for a regency, while George V's illnesses had also highlighted the need for change in case of a monarch's incapacitation. The 1937 Act stated that a monarch under the age of 18, as all these English and Scottish monarchs were at the time of their ascensions, would have a regent to discharge their duties for them. If that monarch was male and their mother was still alive, she would have custody of the monarch's person until their 18th birthday. Funnily enough, though, the fact that the monarch is referred to as a male in that clause means that the rule does not technically apply to a female monarch. In that case, her guardian would in theory be her regent, though in practice I imagine an underage queen would also be allowed to stay with her mother. It also meant that had Queen Elizabeth II died shortly after becoming queen back in 1952, then her husband, Prince Philip, Duke of Edinburgh, would have lost custody of a young Prince Charles to Princess Margaret, as he would not have been the monarch's mother or the regent. Margaret, as the next person in line for the throne over the age of 21, would have fulfilled both functions. This situation led to some additional legislation, which we'll return to in a few minutes. There is also a provision in the 1937 Act covering the highly unlikely scenario that a minor monarch aged 16 or 17 is married to someone who is over the age of 18. In that case, the teenage monarch would be in the custody of their spouse. In the case of someone like George III, who is impaired and unable to carry out their duties, that impairment would first have to be attested to, with medical evidence to support it, by at least 3 out of the following 5 people, none of whom could actually be the regent, thus reducing the chances of a conflict of interest. The monarch's spouse, the Lord Chancellor, the Speaker of the House of Commons, the Lord Chief Justice of England and Wales, and the Master of the Rolls. Only then can a regency be instituted. There is no contingency plan if fewer than 3 of these people are available. For example, if the monarch is unmarried and 2 of the other offices are vacant, or if only 4 of these people are available and the vote is tied. In those cases, a regency simply couldn't be declared. The monarch themselves does not have a vote, nor is there any recourse for them to appeal the decision. Assuming a regency could be and was declared, the regent is to be the next in line to the throne unless they are not a British subject of full age, not resident in the UK, or a Catholic. This means that there is no scenario in which Queen Camilla could be regent unless new legislation is passed. At the moment, the task would fall to Prince William. If the next in line to the throne is themselves a minor, for instance, if Prince William suddenly died, leaving Prince George as the first in line while he is still a child, then it goes to the next person in line who does fulfill the criteria. At the current time, that would be Prince Harry, but only if he immediately moved back to the UK, then Prince Andrew. When Prince George turns 18, he would then take over as regent for his grandfather because he would be the direct heir. Any other regent except the first in line has to be 21. A regent cannot refuse to take up the position, cannot resign it, and a regency in the case of incapacitation would only end either because the monarch was able to resume their duties or because they died. But what if the regent themselves dies or becomes incapacitated? Well, in that case, the regency passes to the next in line to the throne who fulfills the necessary criteria. Furthermore, even if the earlier regent becomes available again, maybe they recover from whatever illness made them unavailable, for instance, they don't get to be regent again. Some alterations were made to this act as the years went by. Remember I said that the first in line to the throne can become regent at the age of 18 rather than 21? Well, that exemption to the 21 rule was only added in 1943. Then, in 1953, came a further amendment, so that if Queen Elizabeth II died or became incapacitated while Prince Charles was still a minor, her husband, Prince Philip, Duke of Edinburgh, would have become regent, rather than her sister, Princess Margaret. Once one of Elizabeth's children, or theoretically grandchildren, was old enough to be regent, though, they would have taken over from Philip. The 1953 amendment was a one-off change, which applied only to Philip and Margaret's situation. As I've said, the current consort, Camilla, cannot be regent short of new legislation being passed, and the 1937 rules continue to be in force. If Prince George became king as a minor, his regent would be his Uncle Harry or his great-uncle Andrew, not his mother Catherine, though she would retain physical custody of her son. Any regent is required to take a number of oaths before the Privy Council, but there are few limits on their powers within the United Kingdom. They are not allowed to alter the rules of the succession or repeal the Act for securing the Protestant religion and Presbyterian church government, but that's about it. Outside the UK, in the rest of the Commonwealth, they would be unable to perform monarchical duties unless those other countries formally recognised their ability to do so, and some have, such as New Zealand in 1986. Before we move on to the Counsellors of State and the question of whether a regency could happen soon, if you're enjoying this content, please take a moment to give the video a thumbs up and subscribe to my channel with the notification bell switched on, so that YouTube lets you know each time I upload. For more from History Calling, you can also find me on Patreon, where I share bonus material including early access to ad-free videos, mini podcasts and blog posts. For instance, this week my time traveller and historical figure patrons are getting a podcast discussing an incident in another European country in the 20th century when the monarch effectively took a day off from being king for reasons which I'll discuss in that podcast, and deliberately rendered themselves unable to fulfil their duties. In addition, I have an Amazon storefront where I've gathered together some recommendations for history-themed books, TV shows, movies and more, and both are linked in the description box below for you, as is my Instagram account. Now for Counsellors of State. Whereas previously the monarch had been able to choose who to appoint, as of 1937 these were limited to the monarch's spouse and the first 4 people in line for the crown who met the necessary age, citizenship, religious and domicile requirements. The Queen Mother lost her position as a counsellor when her husband died in 1952, but was added back onto the list the following year by additional legislation. Interestingly, for the domicile part, this means domicile of origin rather than domicile of choice. That means that Prince Harry is still eligible despite living in the United States of America because he was born in the UK, although a 1943 amendment to the rules means that he can be exempted on the basis of his current living situation. This is different to a regency, which would require him to reside in the UK if he was the regent. By 2022, his status and other factors meant that the situation was not ideal. The new king's potential counsellors of state were Queen Camilla, Prince William, Prince Harry, Prince Andrew and Princess Beatrice. Remember, William's children don't count yet because they're under 21, which is the age limit for counsellors unless they are first in line for the throne. With Harry having fallen out with his family, withdrawn from royal life and relocated to the States, and Andrew having been effectively fired from royal duties, another amendment had to be made to the rules, and so in September of that year, the king's other siblings, Princess Anne and Prince Edward, were added to the list of those who could act as counsellors. As time goes on, Prince George, Princess Charlotte and Prince Louis will eventually become eligible too, as will their mother when she becomes the Queen Consort. The intention is that only working members of the family would ever be called upon, which also effectively rules out Harry, Andrew and Beatrice, and will likely prevent Prince Archie or Princess Lilibet ever being called upon either, though Lilibet is so far down the line of succession I don't think she'll ever break into the top 4 anyway, even if her uncle William dies unexpectedly young, and let's all hope that doesn't happen. Counsellors are always intended to act in pairs, and they lose their position either when their term of appointment comes to an end or when the monarch dies. This is why it was so important that Princess Anne and Prince Edward be added to the list. At the time of his accession, King Charles had only 2 counsellors, Queen Camilla and Prince William, who could realistically be used, and if either one was ill or Camilla went on a foreign trip with the king, then only one functioning counsellor would be left in the United Kingdom and no pair could be created. A remaining flaw in the system is that councillors can only be appointed by the monarch signing a document, but if the monarch is unable to write, then they can't make that appointment. In that case, even if the monarch is otherwise fit and well, the only alternative would be to declare a regency. What about the powers of these councillors? Well, they don't rival a regent's, but they are pretty substantial, and it is perhaps easier to tell you what councillors can't do than what they can. They can't dissolve Parliament without the monarch's express permission, they can't grant any peerage titles, they can't appoint or take audiences with the Prime Minister, and they can't deal with Commonwealth matters. So is it likely that Counsellors of State or a regent will be required as a result of King Charles's current illness? Well, Counsellors of State might be used to ease some of his work burden, but I think a regency at the current time is highly unlikely, unless his condition greatly deteriorates, and at the time this video is being made, that seems unlikely. His cancer was caught early, according to the Prime Minister, and Buckingham Palace has specifically said that the King remains able, quote, to undertake state business and official paperwork as usual. Furthermore, his grandfather, George VI, had cancer too, and there was never a regency for him. Remember also that in order to enforce a regency, 3 out of 5 people, including Queen Camilla but excluding Prince William, would have to agree to it, and with medical advice, so this is not something which can be done easily. If it did happen though, then it would be William who would become regent, unless he was, for some reason, unavailable. Queen Camilla, however, would retain guardianship of the king, as per the same clause I showed you earlier relating to underaged but married monarchs. Queen Elizabeth II was increasingly poorly in the final year or so of her life, but while she delegated duties like the 2022 opening of Parliament to Prince Charles and Prince William in their capacity as Counsellors of State, there was never a regency. The bar for installing one really is very high, as it should be. That brings us to the end of this brief history of regencies and the position of Counsellor of State. Let me know in the comments below what you think of the current rules. Are they fair, or should the monarch be allowed to choose their own regent and/or counsellors? If you'd like to learn more about royal history, try one of these videos next. Whatever you choose, please enjoy, and until next time, keep learning.